I hate you, and I pray you never see daylight again.
She knew it was a setup. She knew her brother was coming with a gun.
But you gave my brother, you didn't kill him, you murdered my brother.
Kevin Sheffield was sentenced today to 50 years in prison for the murders of 2 men in separate shooting incidents. The judge handed down this long sentence after Sheffield pleaded guilty to both murders.
I hate you. And I pray you never see daylight again. I hate you.
In a Dallas courtroom filled with pain and raw emotion, Kevin Sheffield, a convicted murderer, sat expressionless as he listened to powerful victim impact statements. The judge sentenced him to 50 years in prison after Sheffield confessed and pleaded guilty to 2 murders.
We can't even talk like we used to.
In May 2022, in Northeast Dallas, Kevin Sheffield shot and killed 65-year-old Joseph Sias as he was walking home from the store. Police reported that there appeared to be no motive for the senseless act.
But I really hope you ask for forgiveness. Because their blood is on your hands.
I don't know what your mind was going through, and I don't even know what type of animal you are. But you didn't have to kill my brother.
Dallas police apprehended Kevin Sheffield after surveillance footage identified the vehicle he was driving. Ballistics testing later confirmed that a gun found in his home was connected to the murders.
2 years. I waited for this day just to see you. But you gave my brother, you didn't kill him, you murdered my brother. You shot my brother. Went down the street, come back and shot my brother again. Come back and watch my brother die.
Joseph's family members spoke of their deep anger, grief, and sorrow.
I wish they would give you 2 years because I promised to God I would blow your head off, man. I'm not going to touch it. I'm gone. I'm gone. I'm not going to touch it.
Family members also emphasized that Sheffield appeared to show no remorse for his actions.
He sat there and he just looked like he didn't care.
Sheffield's confession also included his admission to shooting another victim, 64-year-old Mohammed Kamara. One of Kamara's relatives also had powerful words to share with Sheffield.
We know that he is off the streets, and my family, we're going to do everything we can to make sure that he serves every bit of those 50 years.
Sheffield has been handed a 50-year sentence for each victim, with both sentences to be served concurrently. He will receive credit for the time he has served and become eligible for parole after 25 years. A Tampa teenager has pleaded guilty to being the mastermind behind a robbery and murder that took place over 2 years ago. Madison McGall and her brother were both involved in the crime and are currently serving prison sentences. However, an error was made regarding Madison's sentence, and now prosecutors seek to correct it. The judge has decided on how to address this issue.
Is that a yes?
Yes, sir.
All right.
Madison McGall was just a teen when she was arrested and charged with orchestrating an armed robbery alongside her brother, Henry McGall. The robbery ended in a tragic murder. Both siblings ultimately accepted plea deals to resolve their cases.
He should do the time. Okay, and he did it maliciously.
Henry received a 25-year prison sentence. According to Madison's plea agreement, she was supposed to serve 5 years in prison, followed by 10 years of probation, adding up to 15 years. However, due to a mistake, Madison ended up serving her prison and probation time simultaneously, reducing her sentence by nearly half. The error was eventually discovered, and prosecutors are now pushing to correct the illegal sentence. The judge has agreed, and Madison must return to court to address the issue.
I'll get that signed, and we can reset this for June 19th.
For years, prosecutor John Terry has described Madison as the mastermind of the 2 siblings, driven by malicious intent.
She had the wherewithal at 15 years old to set up a robbery,
which resulted in the shooting death of Jesse Silver.
She knew it was a setup. She knew her brother was coming with a gun. She actually reached into the car and grabbed the drugs during the course of the robbery. Judge, this is the actions of an adult. Whether she's 15 or not, she did a horrible crime, and Jesse Silver is dead today as a result of that crime.
Madison McGall will be transported from prison back to a Tampa courtroom for her resentencing. More than a year after the devastating loss of Michelle Melendez and her young daughter, Layla Stewart, justice has been served. Kirkland Warren, the man found guilty of their brutal murders, has been sentenced to life in prison without the possibility of parole for both killings. The courtroom was filled with raw emotion as the sentencing was delivered, and outside, friends and family of Michelle and Layla gathered to honor their memory. They shared heartfelt tributes, reflecting on the vibrant lives of the 27-year-old mother and her daughter, emphasizing that their presence is deeply missed and that they deserve to live.
I can't even get phone calls from Michelle to say I'm dropping off Layla or I'm picking her up. I would watch Layla like almost every weekend, and when those weekends come back up, I don't get to see her anymore.
Kirkland Warren was handed a life sentence without the possibility of parole.
Any possibility of this being some horrific accident or being mitigated in any way is squarely contravened by the depraved way in which Michelle and Layla's bodies were disposed of by this defendant.
Kirkland Warren pleaded guilty to charges of first-degree aggravated murder, second-degree murder, and first-degree child molestation. Court documents reveal that Michelle and Layla were last seen on March 12, 2023, leaving a friend's house in Warren's vehicle with Layla holding a kitten. Tragically, on March 22nd, their bodies were discovered in a rural area near Washougal.
And Layla had a little kitten named Rocky. That night, pictures of her, she had a kitten on her shirt. She loved cats. And when Joanna Cardinal put her in the defendant's car, she had Rocky with her. And it's our hope that Rocky was the last thing that she saw at the time in which she passed this earth.
The Clark County Medical Examiner concluded that Michelle died from a single gunshot wound, while Layla suffered 2 gunshot wounds. Lab tests later revealed that Warren had sexually assaulted Layla. Further court records indicate that Warren had previously faced a murder charge in Arkansas, as well as a charge for violating a protective order that Michelle had filed against him. Friends and family of Michelle and Layla expressed their belief that the system failed, and they feel this devastating tragedy could have been prevented. However, Warren has received the maximum possible sentence for aggravated murder in Washington, life in prison without parole. The loved ones of Michelle and Layla say that even this severe punishment doesn't feel like enough.
There were 2 lives taken, and he got 1 life sentence.
Now, Warren will spend his remaining life confined in jail without any chance of release. Once again, the judge handed Warren the maximum penalty, which is life in prison without the possibility of parole. A man from Newton has been charged with the murder of his wife, a case made even more heartbreaking by the details revealed in court. According to investigators, the couple's children witnessed the brutal attack, which occurred while the victim was on the phone with a friend. Authorities disclosed that the woman was attacked with a baseball bat, and the distressing account has left the community in shock. Speaking with neighbors added more heartbreaking elements to the story. The couple had 3 young boys, making the tragedy even more devastating. It's particularly sorrowful to learn that the victim had filed a restraining order against her husband recently, but police hadn't yet had the chance to serve it.
Richard Hanson.
The man accused of violently beating his wife inside their Newton home appeared before a judge and will remain in custody. Richard Hanson, a 64-year-old man, is facing murder charges for the death of his wife Nancy, which occurred on Saturday night. Police were called to the couple's Brookline Street residence after receiving simultaneous emergency calls, one from their son and another from a friend who had been on the phone with Nancy at the time of the alleged assault.
She heard the phone drop, and then several loud bangs could be heard in the background, as well as children screaming, "Dad, stop, you're killing her."
Prosecutors allege that Richard attacked Nancy with a baseball bat after accusing her of infidelity.
We saw someone going out in the ambulance.
Neighbors witnessed the police response and were stunned to learn what investigators say took place inside the kid's bedroom.
Oh, it's awful. I mean, I feel horrible for the kids. I guess it can happen anywhere.
Court documents reveal a troubling history of domestic issues spanning several years. In 2020, Nancy was arrested for kicking Richard, and in 2021, she filed a restraining order after he allegedly threatened to kill her. Most recently, she sought another restraining order, accusing Richard of shutting off her phone and stealing her pocketbook and keys. Unfortunately, police were unable to serve the restraining order in time, and on Saturday night, they found Richard in the driveway following the tragic incident.
He made statements to the effect of she was cheating on me and now he couldn't believe he did that.
Neighbors mentioned that they weren't particularly close to the Hanson, describing them as acquaintances rather than friends. The family seemed ordinary to them, with no outward signs of the issues brewing behind closed doors.
Nancy would walk her kids to school and pick them up every day when they were in elementary school at Memorial Spalding. So I'd see her a lot then.
A friend and former co-worker of Nancy shared her reaction to the tragic news, expressing her deep shock and grief. She also reflected on the vibrant energy and light Nancy brought to those around her. Quinton Phillips has been sentenced to 70 years in prison for his involvement in a drive-by shooting that took the life of young DeEarlvian Whitley. The sentence, delivered by the jury, signifies the heavy price Phillips must pay for the devastating loss he caused. In court, DeEarlvian's mother delivered an emotional reaction to the sentencing of her son's killer.
We therefore assess his punishment at confinement in the Institutional Division of the Texas Department of Criminal Justice for a term of 70 years.
To know you, to know your sister, to know your grandma. This hurts, because out of all people, why? It's an answer I will never get from you or nobody.
Cintwanisha Whitley had strong words for Quinton Phillips. 6 years ago, she was at home with her son, DeEarlvian Whitley, when gunfire erupted. DeEarlvian was struck in the head and died instantly. Now, after all these years, the state considers the sentencing a significant victory.
This defendant, Quinton Phillips, was the driver, so the evidence showed that he most likely did not fire the shot that killed the little boy, so I believe 70 years is a just and appropriate sentence.
The case is far from over, as two other defendants, John Chatmon and Terrell Chase, are still awaiting trial. According to the state, those proceedings may occur in the future, with Chatmon likely to be tried first. DeEarlvian's mother acknowledges how difficult it is, but remains determined to be present to ensure that everyone involved is held accountable.
Just closing one chapter book. I still have 2 more chapter books to close, so I'll be ready for those.
Phillips will now be transferred to a state prison. He will receive credit for the time he has served and will be eligible for parole after completing half his sentence. Dylann Rounds, a 19-year-old with a passion for farming, was determined to transform a remote piece of Utah land into a thriving agricultural operation. Known for his hard work and vision, Dylann had already begun building his dream farm when he mysteriously disappeared in May 2022. His family, alarmed by the sudden lack of communication, traveled to his farm to search for him. There, they discovered Dylann's boots discarded behind a dirt pile, a clue that something was seriously wrong. Despite their pleas for urgent action, law enforcement's initial response was sluggish, leaving the family feeling abandoned during a critical time. James Brenner, a 59-year-old farmhand with a violent past, quickly became the prime suspect. A longtime acquaintance of Dylann's family, Brenner had worked for them in the past and was staying on the property. After the family was asked to leave the area during the early investigation, they suspected Brenner of tampering with evidence, including removing items from the property. His refusal to cooperate with investigators and his prior criminal history further deepened the family's suspicions. For months, Brenner maintained his innocence, prolonging the family's agony as they searched for answers.
The brightness of Dylann's dreams was brutally extinguished. In the days following his disappearance, his family discovered his boots behind a dirt pile. A chilling sign that something was terribly amiss. Despite that critical clue, their pleas for immediate action were met with dismissive and heartbreaking response. Law enforcement not only failed to act with urgency the situation demanded, but they also compounded the family's suffering by asking them to leave the property where Dylann was last seen. They were told their presence was irritating James Brenner. He was not even the property owner. He spent the time, after the family was forced to leave, cleaning up and disposing of items from the shed that was on the property. The family was convinced that evidence was being disposed of, thrown into a pickup truck, and being driven away. But their pleas fell on deaf ears because an individual who had an open warrant for his arrest, who subsequently confessed to this murder, was being irritated. That careless dismissal is a wound that will never heal.
In 2023, Brenner confessed to killing Dylann as part of a plea deal, which required him to help recover Dylann's remains. This cooperation was widely seen as a self-serving act, rather than a display of genuine remorse. Authorities eventually located Dylann's body, providing some closure for his devastated family.
And ultimately, he only came forward with the truth so that he could cut a deal and reduce his sentence. His callous disregard for his family, these people who he knew personally, after doing something so devastating to this family, it had no consideration, no compassion, and no empathy for them at any time. That is who this man truly is. This was not an accident. This was calculated. And every action for 2 years since has been calculated as well, in an effort to try to get away with the cold-hearted murder of Dylann Roof.
While grateful to have Dylann return to them, the family remained haunted by Brenner's betrayal and the cruel circumstances of his death.
I didn't write any speech or anything. I didn't really even know what I was going to say until I got here. I mainly wanted to talk to Jim, and when this all started, when you got arrested, I asked the FBI agent kind of if he knew anything about your past, Jim, to see it. I guess I was trying to figure out a way to forgive you. And then we went to where you laid Dylann, where you tried to bury him. And I asked the same FBI agent if you showed any remorse. And he said you showed no remorse whatsoever that he could see. And you just tried to blame everything on circumstances and whatever. Like I said, I didn't write anything down. I just want you to know what you took away. Not just from me, or his mom, or his brother, and sister. You took away someone who was willing to be active in the society and contribute to society. As far as I can tell, in your whole entire life, you've never contributed to society once. Dylann helped you out so many times, whether it be hauling sugar beets or potatoes or whatever, and this is how you repay him. I just basically hope that you, for the rest of your life, can think about this. And if a 30 year comes about and you get out, it'd probably be the worst thing that ever happened to you, Jim. And in that time, man, this is hard. I just hope the rest of your life, you remember what you did and what you did, and I hope sometime you feel some remorse or some guilt. That's basically all I had to say. And I wasn't going to let you just come in here and limp like a little gimp and walk out with nobody saying anything to you at all. You don't have the balls enough to look at anybody in the eye or even look at anybody. To turn around and look at the people who you've affected. That's all I have to say. Thank you.
During Brenner's sentencing in 2024, Dylann's family and supporters shared heartfelt testimonies about the impact of his loss. They spoke of Dylann's love for life, his dreams, and the bright future that was stolen from him. The court heard about the pain and frustration endured during the search and the deep emotional wounds left by Brenner's actions. The judge acknowledged the calculated nature of Brenner's behavior, including his lack of empathy and refusal to take responsibility. The prosecutors suggested this sentence
wherein the client plead guilty as charged, as charged in the amended information to a second-degree felony on the murder case, carrying a potential penalty of 1 to 15 years, and then as well as pleading guilty in the other case with 2 counts of the possession of a firearm, also each carrying 1 to 15 years of second-degree felonies. That plea deal was executed, the court approved it, and it carried with it terms and conditions that the parties agreed to. A couple of those terms and conditions were that the cases themselves on sentencing would run consecutively, which under the amended information and plea that we made amounts to a maximum sentence under the law of 3 to 30 years. we anticipate that would be the court's ruling today.
The judge followed the agreement.
So there is nothing more than I can do other than what has been agreed upon. Based on the 3 second-degree felonies, it will be the order of the court that you serve 1 to 15 years on each one of those. Those are consecutive. I will give you credit for the time you've served only on those 2 cases, 171 and 110, no other cases. This is in accordance with the agreement, and I want to respect the family with that, and so I'm following that agreement. But I am going to recommend to the parole board that they keep you as long as they legally can. And that's my recommendation to the parole board. I think that's the only leeway I have in this sentencing to offer the family. And with that, that will be the sentence. Anything further, Mr. Manager?
Brenner was sentenced to 30 years in prison with 2 consecutive 15-year terms for his crimes. The judge strongly recommended that Brenner remain incarcerated for the maximum allowable time, citing his dangerous nature and the gravity of his actions. While the sentencing provided a sense of justice, it could not erase the profound sorrow felt by Dylann's family, who continue to honor his memory through their advocacy for others affected by similar tragedies. Dylann's life and legacy remain a testament to his determination, resilience, and the enduring love of those he left behind. Jeffrey Clayton, a longtime educator with over 2 decades of experience, had built a reputation as a respected and influential teacher at Douglas Anderson. His career was marked by accolades and the admiration of many students, parents, and colleagues. However, his professional conduct came under scrutiny following repeated incidents of inappropriate behavior. In 2016, he was reprimanded for stroking a student's back and making comments about her appearance. Despite being explicitly warned and instructed to avoid such behavior, another complaint surfaced in 2021 involving physical contact with a student, resulting in a verbal warning. These warnings did not deter further misconduct.
You have some awards and accolades, and generally also some very good evaluations of your time during your career at Douglas Anderson. But I do note, and I did see, that in 2016 you were reprimanded for inappropriate touching, if you will, stroking a student on her back, complimenting her beauty, and touching her in a way that you were reprimanded and told not to do. Likewise, in 2021, I saw a similar complaint of physical contact. You were given a verbal warning back in 21. So, you know better. You knew better. You should have known better that this type of touching and stroking and certainly kissing was wholly inappropriate, not to mention illegal. So you should have known better.
The case that ultimately led to Clayton's legal troubles involved a girl. His behavior toward the victim, who was his student, constituted a severe breach of trust and a violation of the ethical and legal standards expected of educators. Evidence presented in court included a recorded phone call between Clayton and the victim, described by the judge as deeply unsettling.
It was bad enough that ER was a minor, was a child with whom you engaged, but she was also your student. That's a negative. What a tremendous breach of trust. Not to mention, again, a violation of the law. School is a place where kids go to learn, to grow, and to be safe. No parent can ever imagine sending their child to a school to then be confronted with what ER was confronted with. I have to tell you, listening to that recorded phone call, which I've not heard before, I felt embarrassed, I felt dirty, and I'll say the word that I think some of the other victims said, it was creepy. It was creepy. I was very impactful. Because you don't expect a 65-year-old man who's been previously born and who should know better to do that with a 16-year-old.
In the phone call, he can be heard discussing kissing the victim and expressing his romantic feelings for her.
One day, I'm thinking, I just want to survive this.
And then the next day, I just want to kiss you again.
Additionally, phone records revealed late-night FaceTime calls and over 1,000 text messages between the two. Beyond the primary victim, 7 additional female students came forward with allegations of inappropriate behavior by Clayton, including emotional abuse and physical touching, while Clayton denied any criminal actions regarding these additional students. This is a testimony from another victim.
George being chosen made me feel so special. I feared he would touch my lower stomach and chest or violently pull my hair again.
During the trial, the court considered a wide range of evidence, including testimonies and letters from individuals who spoke to Clayton's positive contributions as an educator. These accounts were weighed against the gravity of his actions and the testimony of the victim. The judge acknowledged the complexity of balancing the defendant's prior achievements with the harm caused by his repeated misconduct, but concluded that the severity of the crimes and the breach of trust outweighed any mitigating factors.
Mr. Clayton, you will be sentenced as follows. On each of counts 1, 2, 3, and 4, I will adjudicate you guilty of each of those counts. And on each of counts 1 and 2, those are the second-degree felonies, these sentences shall run concurrently, and they will be to 10 years in Florida State Prison with credit for the 1 day you have already served. That will be followed by a period of 3 years of probation with the following special conditions. You will have no intentional or direct or indirect contact with ER, the victim in this case, or any other individual named in the plea agreement by their initials, including through a third party, unless approved by the victim, a qualified professional, or the sentencing court. I'm going to order that you continue your counseling, and you may continue it with the counseling that you are currently in once you are released. You will not have any contact with a child under the age of 18 without prior court approval. You will not work for pay or as a volunteer at any place where children regularly congregate, and that includes but is not limited to schools, child care facilities, parks, playgrounds, pet stores, libraries, zoos, theme parks, malls, and any other place where children regularly congregate. You will make restitution to the victim for any necessary medical, related, psychological, psychiatric care. You will pay $518 in mandatory felony court costs, and you will pay a mandatory $151 surcharge for crimes against a minor. On each of counts 3 and 4, those are the third-degree felonies, I will sentence you to 5 years Florida State Prison with credit for 1 day already served, and all 4 counts shall run concurrent.
Clayton was convicted on 4 charges, including 2 second-degree felonies and 2 third-degree felonies. For the second-degree felonies, he was sentenced to 10 years in state prison, to run concurrently, followed by 3 years of probation with strict conditions, including no contact with girls without court approval, mandatory counseling, and restitution for the victim's psychological care. He was also sentenced to 5 years for the third-degree felonies, to run concurrently with the first sentence. Additional penalties included court costs, surcharges for crimes against girls, and restrictions on working or volunteering in environments with girls. On February 22, 2017, a tragic crime unfolded in East Macon, Georgia, when 67-year-old Jimmy Lee Daniel was discovered dead from gunshot wounds in his home on Elder Street. The Bibb County Sheriff's Office launched an intensive investigation into the mysterious homicide, seeking to unravel the events that led to Daniel's untimely death. As detectives dived into the case, they identified 54-year-old Philip Lance Rozier Sr. as the prime suspect. The breakthrough came after a tip submitted to Crime Stoppers led authorities to Rozier's location. On March 1, 2017, Rozier was apprehended at a residence on Carroll Street in Macon. His arrest marked a significant development in the investigation, and charges against him began to solidify. During a commitment hearing, Bibb County Sheriff's investigator, Daniel Shirley, provided testimony linking Rozier to Daniel's murder. The court denied Rozier's bond, ensuring he remained in custody as the legal process continued. The violent nature of the crime sent shockwaves through the East Macon community, leaving residents deeply concerned about safety in the area.
You're Mr. Philip Rozier. Okay, Mr. Rozier, you're here for a commitment here on the charge of 1 count of murder.
Okay, Investigator Shirley, I need for you to raise your right hand. Do you swear that the testimony that you're about to give is true, so help you God?
I do.
State your name and case, please.
Investigator Daniel Shirley, making Bibb County Sheriff's Office, Violent Crimes Unit. Your Honor, on February the 22nd, 2017, the body of Jimmy Daniels was located inside his apartment at 967 Elder Street. The victim shared this apartment with Mr. Phillips. The victim had been shot once in the chest and once in the arm. He was found lying on his kitchen floor on his back. Now, during the investigation, a witness came forward on the scene, which I spoke with. This witness informed me that 2 days prior to discovering the body, that Mr. Rozier had informed him that he was going to kill the victim, Mr. Jimmy Daniel. And the reason for this was due to the fact that the victim supposedly had stolen some items from Mr. Rozier. This same witness also informed me that after the murder, he followed Mr. Rozier to Magnolia and Ramona Avenue, where he witnessed Mr. Rozier throw a black plastic bag into a drain. This witness took me to this location. I looked inside the drain. I saw a black plastic bag. Upon retrieving that bag, I located a 38 caliber pistol along with 2 pairs of brass knuckles. This pistol was fully loaded and had 3 spent shell casings in it. Another witness also came forward and stated that before, after the murder, that Mr. Rozier came to his residence and informed him that he had in fact Mr. Daniel. Warrants were issued for Mr. Rozier. He was picked up on March the 1st. He was brought to the Detective Bureau, at which time he declined to give a statement, and he was transported here to the Bibb County LAC.
So the second witness you spoke of, that's not the first witness?
No, sir.
Okay. And that witness came forward,
I'm sorry.
How did that witness come about?
I received information that this witness, in fact, had information and wanted to talk to me, so I went to his residence and made contact with him and obtained a statement from him.
Okay. And who is the witness that said that they followed Mr. Rozier?
His identity? Due to the safety of these witnesses, I would not like to identify their names at this time.
Okay. Do you know how many people were on the scene when you were there?
People as in
residents, report here that says that there was a gathering of people.
Yes, there were a lot of, yes, there were several people from the neighborhood, or more than several people, large gathering in the area.
And did you interview all those witnesses?
We attempted to speak with the people on the scene, but due to the fact that the information that we had received was that a lot of people in the neighborhood were scared of Mr. Rozier, and they declined to speak at that time.
Was Mr. Rozier part of that same gathering?
Mr. Rozier was on the scene at the time.
And did you interview him?
I did get a statement from him.
And what was that?
Mr. Rozier informed me that the last time that he saw Mr. Daniel was on Monday, 2 days before the discovery of the body. But he had left the apartment on Monday and went across town and stayed with his sister-in-law. Mr. Rozier also stated that on that Wednesday, on the 22nd, he returned to the apartment, went inside to gather some things, at which time he found Mr. Daniel laying on the floor dead. He said that he left or walked out of the apartment and called 911. Now, we were able to disprove that by the first witness that I spoke with, because he came forward that night on the scene and said that he, in fact, was the one that called 911, not Mr. Rozier. We checked the 911 records, and in fact, it was the witness who called 911 and not Mr. Rozier.
Does that witness live in the neighborhood?
He lives in the area.
Okay. And when you found the bag, was there any fingerprints or?
Those items that we located in the drain had been sent off for testing to the FBI, and I'm awaiting results on that now.
Okay.
One other thing, if I may, Your Honor. The 38 that was found, we conducted a search of 967 Elder, and I searched Mr. Rozier's bedroom. .38 caliber rounds, in fact numerous .38 caliber rounds, were found in his bedroom.
In an unforeseen turn of events, Philip Lance Rozier Sr. passed away in August 2018, bringing the legal case against him to an abrupt and unresolved end. His death left the tragic murder of Jimmy Lee Daniel without a definitive conclusion, denying Daniel's family and the community the justice and closure they had been seeking. In August 2018, a deadly confrontation between two former friends in Macon, Georgia, ended in tragedy when 18-year-old Daquan Tyre Falks and 21-year-old Dawan Daniels Jr. exchanged fire. The altercation turned fatal when Falks was struck by bullets, succumbing to his injuries. The incident left the community reeling, highlighting the devastating impact of gun violence, especially among young people. The shooting deeply affected the families and friends of both men, who struggled to come to terms with the irreversible consequences. One life tragically ended and another forever changed. Shortly after the incident, police arrested Daniels, charging him with murder. In March 2022, Daniels faced trial in Bibb County Superior Court. The prosecution presented evidence and testimony from 4 witnesses to support the murder charge. As the trial unfolded and a jury was selected, Daniels ultimately chose to plead guilty to voluntary manslaughter and possession of a firearm during the commission of a felony. This plea represented Daniels' acknowledgement of his role in Falk's death and likely reflected a legal strategy influenced by the mounting evidence and the possibility of a more severe sentence had he been convicted of murder.
Let me tell you something, Mr. Daniel. You may not have pulled the trigger of the gun that fired the bullet into this young man, but you are just as responsible for his death as Mr. Hernandez was. And here's why. This happens all the time. I'm in this room every week dealing with some situation like this. And the reason that we're here is because, and the why is what I don't understand. We now settle our grievances with guns. There are not any fights in the schoolyard anymore like they were when I was 18 years old. Y'all are kids. You were kids when this happened. You got some sort of a beef, we settle and we go. That's why we set records every year for homicides in this community. That's how we settle our differences now. By God, if we disagree with your opinion, if we disagree with you, if we think that you wronged us, you pay for that disagreement with your life. And while you may not have pulled the trigger on that particular gun, you're just as responsible for your friend being dead and for these people suffering as if you had. Because if you hadn't gone to that fight with him, with a gun, he'd still be here. That's why the felony murder statute exists, son. And Ms. Falk is right. I see it all the time. She's absolutely right about that. But what she's wrong about is you don't get hardened to this. I see these faces in my sleep, son. And it's all because this whole generation of people are too immature to settle their differences like reasonable, rational people. We're not going to fight it out. We're not going to talk it out. We're not going to argue it out. We're going to shoot it out. Blood runs on just about every street in this town. And it's because of really bad decisions that you made, Mr. Hernandez made, and that so many other people made. And so we wind up in this room with two broken families. One on that side and one on that side. These people on this side, they're not ever going to see that kid again. The people on this side are going to have to go to the penitentiary to visit that one. One of them winds up in that chair, one of them winds up on these screens with a number underneath his chin. That's the problem. I don't understand it, I've never understand it, and the day they put me in the ground, I won't understand it. so that you know, it bothers the hell out of me. I feel sometimes like I've sent half a generation of kids to the penitentiary for just this kind of stupidity. And that's what it is, son. You can call it pride, you can call it saving face, you can call it standing up, it's stupidity. At the end of the day, it's stupidity. People don't think. They act, and they act with a pistol. When you pull a pistol out, somebody's gonna die most of the time around here. This time it was your friend and their son and their brother. Could have been you. Could have been your face up there with the number underneath your chin. We had a conversation with somebody else. You'll get out. At some point, son, you'll get out. But you're gonna have a long time to think about it. Think about why you were there to start with a gun. But whatever dispute you had with Mr. Hernandez, it wasn't worth what's about to happen in this room. I promise you that. It wasn't worth what happened to those folks on the other side of the room. And it wasn't worth what happened to your daddy and your granddaddy, what's about to happen to your daddy and your granddaddy. There's no way it was worth it. You could have just gone on. But you chose not to. You chose to go there. You chose to go there with a gun. You chose to get in this fight that wound up getting your friend killed. So I'm going to say it to you one more time, and it's the last thing I'm going to say to you before I pronounce sentence. You are just as responsible for that young man being dead as if you had pulled the trigger and put the gun in his head yourself. So on count 3, as to the lesser included offense of voluntary manslaughter, I sentence you to 20 years in the penitentiary. Count 5 required me by law to sentence you to 5 years in the penitentiary consecutive to that. Good luck, son. Anything else, Ms. Milton?
No, Your Honor.
Mr. Raines. That's your fault. Whether you pull the trigger or not, that's your fault too. Think about it. We don't know.
On March 24, 2022, Dawan Daniels Jr. stood before Judge Howard Z. Sims in Bibb County Superior Court for sentencing. Judge Sims handed down a 25-year prison term for the voluntary manslaughter charge, which would run concurrently with a 10-year sentence for possession of a firearm during the commission of a felony. During the sentencing, Judge Sims addressed Daniels, reflecting on the tragic loss of life and the lasting impact of the decisions made on that tragic day. On May 23, 2018, a devastating crash occurred on Bayshore Boulevard in Tampa, Florida, claiming the lives of 24-year-old Jessica Reisinger Raubenold and her daughter, Lilia Raubenold. The tragedy unfolded when 18-year-old Cameron Herrin, driving a Ford Mustang, collided with the pair as they crossed the street. The fatal incident, reportedly caused by street racing, left two families shattered and sparked a high-profile legal battle. Herrin and another driver, John Barrineau, were accused of engaging in a reckless race that led to the collision. According to witnesses and investigators, Herrin was traveling at an alarming speed of 101 miles per hour when he struck Jessica and Lilia, who were walking home from a nearby park. The force of the impact was fatal, leaving the Reisinger Raubenold family grieving and the community horrified. The investigation uncovered further troubling details about Herrin's driving behavior. Data from his Mustang revealed that he had reached a speed of 162 miles per hour just days before the crash. Investigators also confirmed that Herrin had been racing at the time of the collision. Cameron Herrin was arrested and faced charges of vehicular homicide, a second-degree felony, and unlawful racing, a first-degree misdemeanor. His defense, led by attorney John Fitzgibbons, argued that Herrin's age and lack of maturity contributed to his reckless actions. Forensic psychiatrist Dr. Michael Scott Maher testified on Herrin's behalf, explaining that at 18, the brain's decision-making and impulse control systems are still under development, which can impair judgment and foresight. John Barrineau, the second driver involved in the racing incident, chose to plead guilty and was sentenced to 6 years in prison. His punishment also included 15 years of probation and 200 hours of community service, with half of that time dedicated to speaking publicly about the dangers of reckless driving. Jessica Reisinger's mother, Pamela Reisinger, shared her intense grief and heartbreak, expressing sympathy for Herrin's family, while emphasizing that their loss could not compare to the unbearable pain of losing her daughter and granddaughter. She made it clear that no sentence could undo the immense suffering caused by the tragedy. David Robinault, Jessica's husband and Lilia's father, gave a powerful and emotional 45-minute testimony in court, addressing Cameron Herrin directly. He spoke about the enduring pain and sorrow he carries every day due to the deaths of his wife and daughter. David recounted the moments leading up to the tragedy, describing how he had been stuck in traffic and turned down a side street, only to later discover that his family had been involved in the fatal crash. In his heartfelt plea, David urged the judge to impose the maximum sentence on Herrin, advocating for 30 years in prison. He stressed that the incident was not merely an accident, but a reckless and avoidable act that had taken 2 precious lives and left a void that could never be filled.
So it took me a little bit longer than anticipated, but there was a lot of information to consider. Let me just start by saying that as multiple people have observed, this is a particularly difficult case because there's really nothing that the court can do that's capable of fixing the harm that has been caused to the victims in this case. So that being said, I've got to start with the law. I'm bound by the law, and the law gives me a guideline for how to analyze an appropriate sentence in this case. So I want to start with the Camacho case. It's really the first thing I need to address is whether or not the court's going to depart from the minimum in this case, which is 222 months, or approximately 18 and a half years in the Florida State Prison as a minimum. The Camacho case, as Mr. Fitzgibbons pointed out and argued, lays out really a 3-factor test. Is there a valid legal basis for departure? Is there competent substantial evidence that the facts support an application? Or do the facts apply to the departure basis that is being asserted? To both of those questions, I answer those yes. There is a valid legal basis for departure, and there is competent substantial evidence that would support a departure. And really, I'd find that as to all of the departure bases argued, with the exception of the disparity argument. I'll just comment on that one for a moment. The defendant has argued that an available basis for departure is the disparity between the guidelines and the sentence that Mr. Barrineau got. I don't agree with that. I agree that disparity could potentially be an available legal basis for departure. But in this case, I don't think it applies because I do think that there are important substantive differences between the facts as applied to Mr. Barrineau and the facts as applied to Mr. Herrin. The state's put those on the record. I won't elaborate on it too much other than to say I think that the difference, the age of majority for Mr. Herrin is one of those. But mostly I just think that the facts are different as between those two defendants. And so I don't believe that the facts in this case support that as a departure basis because I believe that a disparity in sentence between Mr. Barano and Mr. Herrin is appropriate in this case. That brings me to the third question of should essentially the third factor under the Camacho cases, should the trial court depart? And the court in this case is going to decline to depart. So I'm answering that question in the negative. The trial court in this case is not going to depart. And I don't reach that decision lightly. When evaluating an appropriate sentence, I will start with Florida Statute 921.002. It was pointed out several times the primary purpose of the criminal punishment code in Florida is to punish. And I've got to take into account the severity of the primary offense and the circumstances surrounding the primary offense. When I take into account circumstances and severity, a lot of what I'm taking into account really when I sentence is intent and harm. And in this case, there wasn't any evidence, and nor does the court believe that there was any specific intent to do harm, in this case to the victims. But there was intent to drive at an egregious speed, 102 miles an hour, regardless of the consequences and regardless of who that ended up harming. And then the second part of that, the second component, is the harm caused. And in this case, it's just impossible to have greater harm than the harm that occurred in this case, which was the loss of a mother, loss of a baby, and really the loss of a family as it existed when this occurred. I did consider, I also want to make a record, I did consider sentencing Mr. Herrin as a youthful offender, but for the same reasons that I'm discussing, I didn't think sentencing him as a youthful offender was appropriate. I agree that youthful offender was something that the court could have done. I did consider it. I carefully considered it. But the court just found that due to the serious nature of these offenses, the extreme nature of the conduct, and again, the level of harm, that a youthful offender sentence was not appropriate. So given that the court is not departing, the guidelines call for a sentence of essentially 18 and a half years at a minimum and 30 years as a maximum. And the court doesn't find that either the minimum or the maximum is appropriate in this case. I've said it several times, the serious nature of the offense, egregious nature of the conduct, and mostly the harm that's been caused prevent me from putting this as a bottom of the guidelines minimum case. But the departure bases argued by the defendant did provide some reason not to put it at the top of the maximum. And specifically, the court did take into account that the defendant's 18, certainly responsible for his actions, and he's being held accountable for his actions. But the age of 18, the court finds, is a mitigating factor and shouldn't put this at a maximum. Also, the complete lack of prior criminal history is something that the court considered as preventing this from being at the top. So having said all that, the court is going really toward the middle between the minimum under the guidelines and the maximum punishment permitted under Florida state law. So on count one, vehicular homicide, the court's going to adjudicate the defendant guilty, sentence him to 9 years in the Florida State Prison. On count two, same charge, court will adjudicate the defendant guilty, sentence him to 15 years Florida State Prison, and that'll run consecutive to count one. for a total of 24 years Florida State Prison. Count 3 is a misdemeanor, unlawful racing on a highway. So the court will adjudicate the defendant guilty, sentence him to time served. Give credit for time served, I believe, 2 days. Court will impose mandatory court costs. Mr. Herrin, you have given up the right to appeal the determination of your guilt or innocence. You do have 30 days to appeal the sentence of the court. And I'll direct the bailiffs to take Mr. Herrin into custody. Wish you well, Mr. Herrin.
Cameron Herrin received a 24-year prison sentence for his role in the tragic deaths of Jessica Riesinger Raubenold and her daughter, Lilia. The sentencing came after emotional statements from both families, highlighting the irreversible consequences of Herrin's reckless actions. In court, State Attorney Andrew Warren addressed the gravity of the crime, stating, "This crime took 2 beautiful lives and left 4 families broken. No sentence can repair that damage or bring back the lives lost, but we hope this outcome delivers some comfort and closure for Jessica's and Lilia's families." Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.